Good afternoon. I think it is now possible to speak, and welcome to everybody. This is the seminar that the School of Economics and Political Sciences of the University of Padova has organized to discuss together with a few colleagues and an expert and the students, of course, of our school, so both the Department of Political Sciences and the Department of Economics, to discuss the war in Ukraine. It's not the first initiative that we take in this field. Just last Monday, we had an interesting workshop in which an expert in OSINT has introduced us the techniques of open source investigations. And the work that OSINT experts and detectives, investigators are doing in connection with the war in Ukraine. Today, the scope of our conversation will be a little broader, which is the topic we will deal with is the war in Ukraine from the perspective of international law. To this end, we invited advocate Stefano Trevizan, who is an expert in OSINT as well, and is also an attorney and legal consultant at Lighthouse Reports, to lead our discussion in this field. And there will be also Professor Sara Pennicino and Professor Alberto Lanzavecchia and myself. My name is Paolo De Stefani, to complement, so to say, the introduction and the conversation that Stefano will start. But before starting, I give the floor. I'm really, pleased to give the floor to Tarcisio Gazzini, who is the chair of the School of Economics and Political Sciences. Tarcisio, if you can.
Hello, good afternoon, and greetings from Venice. I'm very glad you have organized this event, and I wish to thank Sara, Alberto, and Paolo. For the school, it was very important to stimulate a reflection on the current crisis in Ukraine. Unfortunately, we are assisting to an outrageous conflict, and it is our duty to stop and reflect. I'm very pleased the meeting will have a focus on international law and especially international criminal law. Often we tend to focus on the rules of military force, negotiations, sanctions, and we tend to neglect the international criminal law aspect. And unfortunately, also the office of the prosecutor has neglected since 2014 the prosecution of the crimes committed in Ukraine. So a debate is overdue, and it's extremely important to put an end to impunity. It's good in the last few years we had several international criminal tribunals, which were far from perfect and rendered decisions which were not always convincing, but they made a huge contribution towards the end of impunity. And they must be appreciated for the big effort they put in enforcing, as far as possible, international criminal law. So I don't want to waste more precious time. And again, I'm very glad to the organizers, and I'm very pleased we have a very good expert leading the discussion today. Thank you very much.
Thank you, Tarcisio. And now is the turn of giving the floor to Stefano Trevizan. So Stefano, if you can turn on your camera, okay. Stefano is already well known by some of us, including some students in courses at the political science department, because he has been conducting a seminar on OSINT techniques last October. As I said, he's a lawyer, he's an expert in OSINT, and also legal consultant at Lighthouse Reports, which is an organization that uses this sort of techniques to do investigations, to also participate in litigation and support investigative journalism worldwide. And with him, the idea today is to have a conversation, as I said, about international law in general. Of course, there will be a focus on international criminal law, but as you know, the investigation of the ICC has just started and many information are just not public. So we decided to expand a little bit the scope of this conversation to include also the important steps that the ICJ, for example, International Court of Justice, has taken recently, to the role of the Council of Europe, to the role of the international community, of course, the United Nations, the historic resolution that was adopted a few days after the aggression, of Russia against Ukraine. So I'm pleased to give him the floor. After his presentation that will last 40-45 minutes, let's say, give him, we decided to give him a little space. There will be a question and answer session. So we will open the conversation with you, the public. You will have to use the chat system to write your questions, and I, supported by Sara and Alberto, will go through your questions and report the question to Stefano, or even try ourselves to take some of the questions if they fall within the field of expertise that some of us may have. So eventually, if some topics will not want to be covered by the questions and the replies coming from the speakers, we will also add maybe some short speeches just to complement the whole picture. Now it's time for me to stop talking and give the floor to Stefano, who probably has a nice presentation for us to show.
Thank you so much, Professor Paolo De Stefani, and I want to also thank you, University of Padua and School of Economics and Political Sciences, for inviting me for this meeting today, for this webinar. I also want to thank Tarcisio Gazzini and Professor Sara Penicino and Professor Alberto Lanzavecchia. It is a true honor to be with you today, and I hope I can make the expectation of this webinar and I hope that is going to be interesting for you. Professor De Stefani, I think you need to allow me to share my screen, if it's possible, or I ask also Sara Penicino.
Okay, now you should be able to do it. You are co-organizer.
Yeah. Thank you so much. Now you should be able to see my screen, right?
Perfect.
Yes.
Okay, thank you so much. So as it has been introduced by Professor Paolo De Stefani, today we're going to speak about the war in Ukraine. My presentation is going to last for about 40 minutes. Please note down the question you may have so that we can open up discussion at the end of the presentation. Just a very brief introduction. I didn't know that Professor Paolo De Stefani would have introduced me. So my name is Stefano Trevizan. I'm an attorney at law. Actually, I'm a practicing lawyer in Padua. I hold an LLM in international law and human rights. I've been trained in international organization and specifically in the Human Rights Department of the United Nations, of the European Commission, and at the European Center for Constitution and Human Rights. But currently, I'm associate and legal consultant at Lighthouse Reports, which is a non-profit investigative agency that is based in the Netherlands. My main area of expertise is open source investigation into human rights violation and war crimes. I've been working specifically in the context of the Yemen armed conflict, and Syria, and now in Ukraine. So let's now turn to the topic of today's session, the war in Ukraine and recent development in international law. The purpose of this presentation is to provide a few references to recent international law measures that have been adopted by international institutions. So I tried not to disclose any political statements, although at the very end of the presentation, I'll try to present also some point of view that are not strictly legal. So with that in mind, I will talk about three main recent developments in international law. The first is about the resolutions adopted within the United Nations, United Nations General Assembly and Security Council. The second topic will be the proceedings that has been initiated by Ukraine against Russia before the International Court of Justice. And the third one, and finally, I'm gonna discuss a few elements about the investigation launched recently at the International Criminal Court. So I'll try to answer with this presentation whether the invasion of Ukraine by Russia is a failure of international law, as many experts are commenting at the moment, even at academic level, whether international law, in other terms, is still able to solve international crises or isn't fitted for these kind of problems. So let's start with a very short timeline. I'm sure that you all know the events that took place, but just a short remind for everyone. On 21st of February this year, Russia, the government, recognized the so-called Donetsk and Luhansk Republic as independent states. You will remember this scene. President of Russian Federation, Vladimir Putin, on the evening of the 24th of February, in a speech that was televised, was broadcasted on television, he announced that Russia would have launched what he called a special military operation, which has been resulted in the invasion of Ukraine. So the speech that he made in television is particularly interesting also for lawyers. It does include political statements, but it does also include the legal justification of the invasion itself that have been transcribed and submitted to the Security Council. So when it comes to political statements, Vladimir Putin condemns the eastward expansion of NATO, which, according to his point of view, poses a threat to Russia, to its security and independence, and also condemned what he called Western exceptionalism, alleging that Western powers and specifically United States of America have breached the very fundamental of international law that have been established after the Second World War, with the crisis that Putin referred expressively on Serbia, Libya, Syria, and Iraq, that according to his point of view are clearly example of international law. Therefore, Vladimir Putin spells out what are the legal justification of this special military operation. These are mixed justification. There are more than one. The first one is an humanitarian protection operation that aims to prevent acts of genocide that have been committed in Donbass. Again, according to the declaration of war that has been laid down by President of Russia Federation. The second reason, legal justification of the war, according to Vladimir Putin, is collective self-defense. So protecting Donetsk and Luhansk republics that has to be protected by Russia itself. And the third one is individual self-defense of Russia itself from the eastward expansion of NATO. So according to Vladimir Putin, the location of military units in Ukraine and the ongoing negotiation, at least at that time, between Ukraine and NATO poses an imminent threat Russia, one that should be reacted against by Russian Federation. So I said this very political speech that was broadcast in television was transcribed fully. You can look at it online, and it was submitted as an attached document to a letter filed with the Security Council that night, with which Vladimir Putin notified the Security Council that is acting under Article 51 of the UN Charter in launching this military operation. So the legal framework, of course, of this conduct is the UN Charter, which is the founding treaty, a multilateral treaty of the United Nations. As you will know, Article 4, paragraph 2 of the United Nations Charter prohibits the use of force against the territorial integrity or political independence of any state. However, there are three different exceptions to this prohibition. The first one that has been invoked by Vladimir Putin himself is Article 51, so individual and collective self-defense. The second one, the second exception to the prohibition of the use of force is authorization of the Security Council, which has not been adopted in this case. And the third one, which has not been enshrined in the treaty, but is state practice, so-called, it's use of force with the aim of conducting a humanitarian intervention. So, on the 24th of February, the special military operation was launched in Ukraine, which is the greatest use of military force in Europe since the Second World War. The impact on the ground has been dreadful. According to the most recent UN report, more than 1,100 civilians have been killed, including more than 50 children. 3.6 million of refugees seek humanitarian aid. 6.5 people are displaced internally in Ukraine, and around 3,000 houses, civilian houses, have been destroyed. So let's now turn to what reaction has been, what measures have been taken by international community using the tools provided by international law. So let's turn to the first chapter of this presentation. Let's now look to the United Nations. On the 25th of February, the Security Council rejected a draft resolution that would have condemned Russian invasion. And this resolution was vetoed by Russia, and also UAE, China, and India abstained. Therefore, a few days after, Security Council calls the General Assembly to hold what is called an emergency special session under Uniting for Peace procedure. Now, this is a very interesting development in international law, because Uniting for Peace procedure has been called only 10 times before this incident, so very rarely. It's a procedure that has been established in 1950, in the Korea crisis, and the resolution itself that lays down the procedure says that when Security Council, so the permanent and both permanent and non-permanent states, fails to maintain peace because of lack of unanimity, the General Assembly can be called to adopt recommendations. So, according to the Uniting for Peace procedure, the General Assembly adopted a resolution on March 1st, and in this resolution condemns the aggression of Russia. So it's a very important resolution which deplores in the strongest term, the aggression, and aggression, it's a technical term which is also identifying international crime, as we will see. And it demands that the Russian Federation immediately ceases the use of force. The resolutions also demands that the Russian Federation reverse the recognition of Donetsk and Luhansk republics, and also demands that all parties fully comply with their obligation on international humanitarian law, which is the law that regulates armed conflict. So let's now look at the votes in the General Assembly. More than 140 states voted in favor, only 5 voted against, among them North Korea, Eritrea, Syria, Russia, and Belarus, and 35 abstained, including China, India, Pakistan, South Africa, Iraq, and Iran. Now, it may appear that this is a great majority, a very strong majority, and it shows in a way, alliances of international community against Russian invasion. But actually, if you look at a map of the world, you will see here, colored in orange, the countries that abstained are more than half of Asian and African countries. So there is actually kind of a disagreement, at least at the very the level of the General Assembly, whether this is fully legal operations, given so many countries in Africa and in Asia abstained. So you may ask yourself, what's next? What's the consequences of these resolutions? The resolution is legally not binding. It's a recommendation, but it has a political value. As many academics have noted, labeling Vladimir Putin as outlaw, it isolates him politically and weakens his bargaining power in the ongoing peace negotiation efforts that are ongoing now. Now, the Human Rights Council of the United Nations established a commission of inquiry on March 4th, based on this resolution that will investigate over human rights, international humanitarian law violations. But the General Assembly could also recommend sanctions against Russia, and these happened during the 80s against South Africa for apartheid. And when the UN General Assembly recommend international community, for example, not to conduct international trade with South Africa. But United Nations General Assembly could also recommend peacekeeping operation, provided that these are agreed by the parties in the conflict, as it happened between Egypt and Israel in the 50s. So let's now turn to the second important development at the international law level in reaction of this invasion, of this aggression. And this is certainly the case of the proceedings initiated by Ukraine at the International Court of Justice. So the International Court of Justice is the main judicial organ of the United Nations. It has been established after the Second World War. It's sitting in Den Haag, and its main function is to settle interstate disputes. So Ukraine on February 26 filed an application with the court based on the 1951 Convention on the Prevention and Punishment of the Crime of Genocide. So this legal intervention has been defined by many experts as an unconventional or original approach to this very convention of on the prevention of genocide. Why so? Well, because Ukraine in court alleged that Russia has made a false allegation of genocide, the one that Putin spelled out when he made that political speech in television that was broadcasted. So Ukraine said that these are false allegations of genocide, and therefore the special military operation is therefore illegal, unlawful, based on the convention that prevents genocide. In other words, Ukraine requests provisional measure to be adopted by the court. So the court should, according to Ukraine, declare a non-violation of the Convention on Genocide and should order Russia to immediately suspend the military operations. On the other hand, looking at the defense bench, Russia said that the special military operation was based on Article 51 of the United Nations, the legal justification was based on individual self-defense. And the reference to genocide that was laid down in the political speech that has been submitted to the Security Council was ad colorandum, was only providing a general context, a reference to the humanitarian situation on the ground, according to Russian official position, but does not trigger the convention itself. So according to Russia, the International Court of Justice has no jurisdiction on the case because the convention is not triggered. So there's no dispute in a way. So it's interesting to comment this case because the interim measure has been already adopted by the court. So the proceedings has been closed, at least in the interim measure, and then we are approaching the merit. So in the interim measure, the court ruled that there is no evidence that Ukraine has committed acts of genocide in the Donetsk and Luhansk republics, according to UN reports. And furthermore, the court stated that the Genocide Convention that has been invoked by Ukraine does not allow the use of force. So in the final verdict, the court sentenced that Ukraine is entitled not to be subject to a military operation for the purpose of preventing and punishing genocide, and that Russia must immediately suspend the military operation. So this is a very urgent order that has been adopted by the International Court of Justice. So again, we may ask ourselves, what's next? What's the consequences of this ruling, of this judgment? So again, in the judgment, the court held that the Russian invasion is unlawful. These, compared to the UN General Assembly resolutions, the court decision is legally binding, although the court itself has no enforcing powers. So some experts have argued that because of the ruling of the International Court of Justice, one can legitimately argue that sanctions are legitimate. The economic sanctions that we're going to also discuss later are therefore legitimate. And one personal comment is that if the invasion is unlawful, therefore multinational companies that have suspended operation in Russia, that are not conducting business anymore, they cannot be held accountable in court because of breach of contracts. Because the status quo is defined, has been qualified as legal by the International Court of Justice. So let's now approach, heading towards the end of this presentation. Let's now look at the third and final aspect of international law that we deem is very interesting to discuss about, to talk about, and certainly is the criminal investigation that has been launched recently by the International Criminal Court. So the new prosecutor of the International Criminal Court, Mr. Khan, on February 28th launched a criminal investigation. More than 39 states parties to the Rome Statute support such legal initiative, and the case has been assigned to pre-trial stage. So the prosecutor announced that he will conduct investigation on 3 different crimes, international crimes. This is war crime, crime against humanity, and genocide. However, the court has no jurisdiction to investigate over the crime of aggression for 2 main reasons. One is that Russia is not a party to the Rome Statute. And secondly, Ukraine has not ratified the Kampala Treaty that in 2010 amended the Rome Statute and included the crime of aggression. So in this case, the court cannot investigate over this crime. So war crime has been defined, is defined under Article 8 of the Rome Statute as willful killing of civilians or willful causing great suffering or serious injury to body or health. And I think it's also important to remind ourselves the definition of civilians. According to the first additional protocol of the Geneva Convention, Article 50, civilians are those who do not participate in hostilities and who do not carry arms. So we discussed a few incidents that may amount to war crime on Monday on a webinar that was organized by the School of Economics and Political Science. So one of the most probably famous incidents that took place on March 16 was the airstrikes in Mariupol that I'm sure everyone has heard about. What is interesting here is that according to open source information, meaning satellite images, close to the theater, you can read that it was written in Cyrillic and still is written in Cyrillic, children, as it is indicated by the red cycles there. It means that the civilian population clearly indicated the presence of non-combatants on the ground, and therefore this building was clearly identified as a civilian objective who could not be targeted by the Russian army according to international humanitarian law and also according to international criminal law. However, the theater was hit by Russian airstrikes, and so satellite images again shows in the aftermath of the event how the building was resulted after the airstrikes. So also other different kind of open source documents and evidence have been in a way documenting these incidents. This is a video that was posted on Twitter that shows the internal rooms of the building, of the theater in the aftermath of the airstrikes. You can notice that people are clearly civilians. They are not wearing any arms, and there were children, women, and old people. This is the effects of the airstrikes in the aftermath. So, and it will be interesting to see whether the prosecutor and International Criminal Court will use such evidence in his case. So, turning back to the initial question, is Russian invasion of Ukraine a failure of international law? I'd like to try to give an answer, recalling what a professor of international law from the University of Padua said in similar circumstances at the beginning of the last century. So Professor Enrico Catellani was professor of international law at the University of Padua. His work has been recently disclosed at the library. In the inaugural speech of the Academy in 1915, when Italy entered in the First World War conflict, when students asked him, is this a failure of the Society of Nations, of international law as we know it? And Professor stated something interesting, that people should not have no illusionary hopes, nor delusional mind. And with these, he meant that on the illusionary hope side, the international community is not regulated by a constitutional order, and therefore it is unable to provide effective short-term solution to armed conflict, because there is no overarching power that can enforce its own measures, because of states who are the subject of international law are independent and sovereign political subjects. On the other side, on the delusional side, Professor Catellani said that international community still does exist, as it exists in network, in relations, in practice, and it exists even in time of war. So this international community is able to take action to establish peace and security. So he was kind of an optimist, but at the same time realist, facing reality in a way. And I'd also like to conclude the press release that have been published by European Center for Constitution and Human Rights, that is based in Berlin. I truly appreciate and admire the work of this international lawyer and human rights activist. So in the press release, ICCHR stated that the international law has been in crisis for more than just a month. It's not just with the Ukraine crisis that international law is a way fragile system. And ICCHR noted that Western states have contributed significantly in the weakening of these international institutions. And they refer to the case of Iraq, Syria, Yemen, Afghanistan, Libya, where acts of torture, war crimes, aggression have been committed, and in a way deprive legitimacy and political power the international institutions. So the ICCHR suggests to reform probably the most important, most powerful body at the international level, which is the Security Council, because the way it's structured and designed right now is dysfunctional because of the veto rights. And the Security Council should be reformed in a way that is more viable and democratic. So a more just international community that should be reflected also in its institutions. So with this, I think I kept in 40 minutes. I thank you for the attention. I'm now interrupting my presentation. Thank you so much again for giving me this space. If you have questions specifically more to professors that are present here, I'd be happy to participate to this roundtable.
Okay, thank you. Thank you, Stefano, for this very comprehensive presentation. We touched upon the main chapters that now under international law are trying to frame the situation in Ukraine. So the work of the UN, the political bodies, the General Assembly, of course, because the Security Council, as you just said, is sort of stopped by the veto and other political issues. The ICJ, International Court of Justice, that has issued a very interesting and innovative, I would say, decision. Of course, it's not a final decision, it's just preliminary measures, urgent measures that should be taken by both parties to stop the war. And then the ICC, which is promising, but it's just at the beginning, and there are a lot of problems that both in the field and in the comprehensive, political landscape must be addressed in order to make this. There have been also some proposals to establish, instead of just following the ICC procedure, to establish a new entity, sort of ad hoc tribunal that could maybe possibly also consider the crime of aggression, because as the situation is now under the statute and the new rules concerning the crime of aggression, Russia cannot be, Russians, let's say, leaders cannot be prosecuted for that crime. So a new institution should be established in case, but of course this is something for the future. I would, of course, there will be a lot of things to say and to comment, to expand also your presentation. I would give the floor immediately to the audience. There is a first question coming from Beatrice, who says, who asks, why is the resolution of the ICJ, the resolution, the decision on preliminary issues, not enforceable? So maybe you can comment a little on that. And then again, Beatrice also asks, how feasible do you think it is, the reform, of the veto system in the Security Council, any specific procedure to avoid China and Russia from vetoing the reform? Because of course, reforms must be also must pass a majority in the General Assembly. Okay, so the first is what's the legal obligation stemming from the ICJ decision? If you may comment on this, but
yeah, I may comment on the first question, that I leave to others who want to intervene also. So it has been noted by international lawyers that the ICJ does not have enforcing powers, does not have an enforcing authorities, but it has also been noted that no courts, actually, even national court, even the tribunal in Padua, has enforcing authority. What gives enforcing power to a ruling is the enforcing authority themselves, who are part of the police or the government, or are, according to the separation of power rule principles, this is a separate power, right? The problem is that the ICJ lacks a separate power to whom it can demand to enforce the ruling, because it relies, in other words, on the collaboration, on cooperation of state parties and their own legal orders. So, therefore, if Russia doesn't want to comply with the ruling, there is no there are sanctions already, but there's nothing that can stop physically Russian. There's no police that coming from the legal order of the International Court that can enforce these rulings. That's why he's problematic. That's why also has been commented by some that this very courageous and original approach is showed by the court. In fact, it results in a ruling that is toothless. So many wonder why this was needed. On the other hand, and I conclude, some others believe that the court could not have acted differently, because the situation really required this kind of urgent and provisional measure to be implemented. Yeah, if anyone wants to comment, or I leave the floor for the second question.
I think you got the point. I mean, the decision of the ICJ, of course, are very authoritative on the legal level, but to give them some teeth, you need political powers. And the Security Council, unfortunately, is blocked by the veto system. You mentioned the United for Freedom decisions of the United for Peace, sorry, decision of the General Assembly that could be, in a sense, taking into account the powers that the General Assembly has seized in the 50s to launch some peacekeeping operations, bypassing to a certain extent the Security Council, but this was sort of exceptional circumstances and then quite difficult to replicate them in the present condition, although it is still something that the General Assembly could consider. I don't know if you can move to the next question that I see here that relates to the consideration. In the last days, right, I don't know exactly who, the last days we have observed many governments allocating large chunks of their budget to the military industry. So I wanted to know your thoughts on this. Are we preparing for the war too? I think this is a question for all of us. I don't know if Sara or Alberto may, I don't know, say their thoughts.
I'm happy to contribute from the constitutional perspective, but I see Alberto shared a very interesting link to data. So maybe we can split the contribution. From a constitutional perspective, what is happening is that different European member states are reconsidering the translation of constitutional provisions on their stance with regard to war and for the use of armed force in general into legislative and constitutional norms and amendments. The most well-known, the most discussed is that of Germany, of course, which is impressive because we know that Germany has, after the Second World War, respected these constitutional limitation on the expenses that the parliament has authorized on the military, on weapons in general. Everybody that is slightly familiar with the security issues knows that the German army is definitely not the point of reference for excellence in the European continent. It never was, for evident reasons, after the Second World War. And the speech that was delivered by the Chancellor in the Parliament was outstanding and was a break away from a well-established tradition. Now, this change should be framed in a larger discourse on a demand from various NATO partners on enhancing the expenditures of individual members with regard to armed forces and weapons and security in general. So this is something that this is a discussion that has been going on for quite a long time in the context of NATO. So if I'm again, from a bottom-up perspective, my perception is that this is an occasion that offer the opportunity to a number of member states to implement a reform and to shift the direction of their attitude towards the amount of the budget that they will spend on security that had been demanded in the past, and that in the context of, again, the NATO partnership had been advocated and had been basically agreed upon. This is something that comes and was kind of expected. So yes, this, and if I may, even with regard to before, and I'm not going to steal too much time, but the war in Ukraine will cause and will imply a number of constitutional changes at a national level. even the whole ordeal about Ukraine accessing the European Union and NATO, this has strong constitutional implications in Ukraine, as this is all mandated by the Ukrainian constitution. So there's a whole issue about what is going to happen after the peace agreements, should this ever happen, and should this be part of those agreements. There will have to be constitutional solutions to the new assessment, to the new framework of constitutional law in Ukraine. The constitution will have to be changed because at this point in history, it says something completely different from what they may actually put down in the agreement.
Yeah, thank you. There is a question that maybe needs clarifications, because Gubolkar asks, so what will be the basis for the ICC investigation in Ukraine, since neither Russia nor Ukraine are parties to the ICC? So if you can briefly, maybe Stefano, clarify this point. I think it was mentioned, but maybe it can be.
Yeah, so Ukraine is not a party to the Rome Statute, but submitted a letter with which it accepted the jurisdiction of the court. And it's interesting to note that the time frame of this jurisdiction is since 2014 onward, and it includes both acts committed by Ukraine and Russia. So therefore, this is the legal base. Also, the fact, well, yeah, I've seen it in one of the question on under which circumstance the prosecutor can act. So in this case, 39 states submit a request to the prosecutor to act. Actually, Italy was not among them. To launch an investigation. And therefore, according to Article 14 and 15 of the Rome Statutes, the prosecutor open a case. The fact that Russia is not a party to a Rome Statute does not prevent the prosecutor to investigate over Russian conducts. This is the case, for example, with the situation in Palestine, right? Israel is not a party to the Rome Statute, but nevertheless, Palestine is. So, since very recently, so that's why we do have an open investigation in that context as well.
Yeah. Then I see Maria Grazia, who asks whether it would be possible for the ICJ to overturn the decision in the future, especially if the allegations regarding war crimes could be proved. Well, in that case, it wouldn't be a kind of overturn. It would be sort of continuation of the case based on new elements of new evidence.
Well, actually, the interim measure. So this phase is concluded. And it was concluded with the adoption of a provisional measure. I guess that the court could modify the provisional measure if it's requested by Russia. But in any case, there will be a legal assessment on the merit as well, which will take years, I guess, where the court will assess whether, in fact, these acts of genocide have happened in Ukraine. And also, it will be interesting to know whether the court accepts the request for a reparation that has been submitted by Ukraine for the conducts committed by Russia.
Lilia is still insisting on the fact on the problem of enforcement. So even the decision United for Peace of the General Assembly would need to be enforced. And so even if it were adopted, still the enforcement issue is still would remain. But of course, at least you have a legal basis. I mean, for all governments and states, not just those who are now involved in the sanctions, to take measures to stop the invasion and to, take countermeasures against Russia and those who support Russia. So there's the potential for some reactions, for some more, concrete measures of enforcement would be present. And then Lorenzo, is there a possibility that the three proceedings come to different conclusions? So in which ways and how much are the three bodies, and especially the two judicial ones, cooperating? So is there a basis of potential basis for cooperation between the ICJ and the ICC, or should they remain separate and independent in their proceedings, possibly also coming to sort of opposing conclusions, conclusions that are not necessarily converging?
Yeah, I think it's certainly possible that the courts reach different conclusions. That happens at national level, so civilian and criminal court can reach different decision. That's also because the evidentiary threshold is different. In the criminal court, accountability must be proved beyond any reasonable doubt. So there's a burden of proof on the prosecutor. At the civilian level, International Court of Justice is a more dispute settled. That's not the case. So it might be that the ICJ finds that, for example, no genocide have been committed by Russia on the other end, and the ICJ finds the contrary. So that's certainly a possibility. I'm not sure whether there might be collaboration between the two institutions. What I certainly believe is that the commission of inquiry that has been established by the Human Rights Council, one of its scope is to provide evidence that can be used for legal proceedings as well. That's indicated in the resolution. So that's a possibility for collaboration. Yeah,
in the case of Srebrenica and Serbia genocide, the ICJ relied heavily on the findings of the International Tribunal for former Yugoslavia, but it's also true that that decision came years after the ICTY concluded in the Kirstich and other cases. Yeah, and as you said, the level of the threshold of evidence is different in the two bodies. So what is decided beyond any reasonable doubts by the by the ICC should be, in a sense, mandatory also for the ICJ. Another question is about the regional organizations. Do they really have a role to play in this scenario, or do they have too many limitations in their field of actions? The reference here is probably to OSCE or to the Council of Europe, I suppose.
Well, if I may contribute, I just like to remind that to recall the fact that the Constitutional Court of Russia issued not one but more than one decision, which made very, very clear that they do not accept, for example, judgments of the European Court of Human Rights as mandatory or as in any way binding the lawmakers in Russia. They accept them as advice, kind of opinions that can be considered or not by the Russian legislators. So with regard to regional organizations, I'd say that in the case of the Council of Europe, it definitely means something. The fact that Russia was suspended it sends a signal, as Paolo was saying before, regarding what is the meaning then of an interim order? What is the purpose? It's a signal. It's a community saying, no, this is not acceptable. But in terms of binding decisions, I'd say that the conditions to have that type of connection between regional organizations and any limitation on the Russian government wasn't there even before. So I would imagine that it's not going to this is not going to change in the near future. With regard to OSCE, as you all know, they had a mission, an observer missions in Donbass and Donetsk. Then after the death of one of the participants one of the observers, they retrieved the mission. So at this point, I would say that OSCE is on a standoff. I think they're observing, they're doing something on the borders regarding the movements of people, but they're not on the ground anymore in areas of the conflict. So I don't know. I don't think OSCE can be super effective at this point. Maybe later.
If I may add a little things concerning the Council of Europe, as you know, since the 16th of March, Russia ceased to be a member of the Council of Europe. One day before, Russia sort of withdrew from the Council of Europe, from the organization, but apparently, but it had been previously suspended by the Committee of Ministers on a resolution taken by the Parliamentary Assembly. So it seems that in any case, the situation now is that Russia is no longer a party to this organization, meaning that it ceases to be a member of the ECRI, the Greco, all these bodies that monitor human rights at the continental level, and in particular in Russia. In particular, is no longer a member. It's going to be excluded from the jurisdiction of the European Court of Human Rights. This will take some months, 6 months. So in the meantime, between the 16th of March and the 16th of September, still cases can be brought before the European Court of Human Rights. And actually, we don't know exactly what would happen to these cases, because if the Russian judge decides not to participate in any hearing, or if Russia just say, I don't give you any information, I don't submit any report, I don't respond to any request for cooperation and so on, it's quite doubtful what would be the fate of these cases. But until next autumn, still Russia is part of the game, and this is a little let's say satisfaction actually. I think in this case we really touch some contradictions of international order. So on one hand, you have the logic of membership in an international organization that says that these states that do not behave must be sanctioned, must be punished, and the biggest punish you have, the strongest punishment that you can use is to just suspend and cease cooperation with them. But there is also the other logic, the logic of populations, the logic of human rights. In so doing, all those who are under the jurisdiction of Russian leaders, including those who are under the jurisdiction of the Russian army, are sort of deprived of a form of protection, which in the current constitutional situation of Russia is particularly reason of concern, and particularly sad, I would say, because quality of justice in Russia, especially in matters that intrude into the political areas, are going to be affected by the current situation. There is a question from Maria Grazia, who wishes to know what to be commented about the positive vote in the UN General Assembly of Afghanistan in regard to the condemnation of the Russian action. What could be the reason why such a position was adopted, since they are voting with the West?
Well, I can share my theory, but it's a theory. But as you probably, well, one of the possible reasons can be that there would have been no Afghanistan invasion of the mission, the US first, and then the coalition, if Russia did not allow troops to be moved on Russian soil. Because troops could not, boots on the ground were not possible unless they were allowed in through Russia. Well, not Russia technically, but one of the republics that is basically under the influence of Russia. So in theory, this is the reason why. And then, of course, you have the historical precedent of, I mean, this is not exactly countries that have a friendly relations if you go back in history. So now that considering the political situation in Afghanistan, I think it kind of makes sense.
Another question comes from Massan. She asks, under what circumstances did the prosecutor of the ICC start the investigation? Shouldn't the investigation started by the prosecutor necessarily be after making sure national courts have not taken measures? Okay, this is about the maybe the next step of the procedure before the ICC. Once ascertained that there is jurisdiction, that is a matter, then admissibility and complementarity, in a sense, should be tested. I don't know, Stefano, if you can add anything.
No, not much to add. According to Article 1 of the Rome Statute, the court exercised jurisdiction based on the principle of complementarity. So it must ascertain whether any thorough and serious investigation will be conducted by a Russian authority, which will be hardly the case. So, yes.
Mm-hmm. Then there is Beatrice. After the procedure before the ICC, what would be the effects of the final decision? Would be enforceable? Again, a question concerning enforceability of this decision. Well, in the case of the ICC, the decision would concern some individuals, the leaders, I don't know, Putin or someone else. So, well, some measures against individuals can actually be taken, in the sense of states can decide to cooperate with the ICC. But at least these people affected by the decision would be prevented from traveling abroad, for example. And if they travel, and they can potentially be arrested and brought to The Hague to stand the trial.
Or they could be strong harmed into doing it.
Yeah, of
Serbia
course,
style. Croatia, Serbia style.
Yes, sure. And the trial, by the way, I mean, to stand the trial, not to purge the sentence, because at the ICC you cannot be prosecuted in absentia. So again, Gubolkar makes a comment. Russia is not going to respect any of the international courts, unfortunately. As far as I know, there is a proposal to create human rights courts in the space of of some post-Soviet Union countries. Of course, it is absurd. This is another example of how the world is dividing into two parts and two sets. Yeah. Irina asks, was the information about the hitting by Russian airstrikes of the Red Cross building in Mariupol fact-checked and confirmed? How should this war crime affect the attackers? How should the international community react to this shooting at the Red Cross?
I don't have information about this specific incident. However, I think it's a good opportunity to quickly speak about this Center for Information Resilience, the project that we presented on Monday. So you can type in Google the name of this project. It will pop up a map, an interactive map of Ukraine, and investigators from Bellingcat, forensic architecture, lighthouse reports, so the best one in the field, are conducting this worldwide investigation, open source, so digitally, to in a way collect, identify, and verify this kind of material. And so you can click on the different dots, and you can see red, orange, and green dots according to the level of violence. These are mostly video posted on Telegram, Twitter, Facebook, Instagram, TikTok, and it will be interesting to know, to explore to what extent this kind of material will be used by the ICC in the future, or in what way it changes the narrative of the conflict itself, since many information shared by Russian army can be debunked, as Professor De Stefano was saying before. And of course, the website of Bellingcat, I think it's super interesting to dive into, because they explain the methodology of on investigators. So it's super interesting pieces that will teach you or explain what kind of logical chains investigators do in a specific case alleging war crimes or crimes against humanity.
Yeah, there is a question that this is probably for political scientists or historians. When Georgia was attacked by Russia, there was no such reaction from the international community. And this is really due to a lot of geopolitical implications, and not only, but is it possible that the Heartland Theory has something to do with the cohesive reaction of the world? It is possible that Putin believes in the Heartland Theory. Who rules East Europe commands the Heartland. Who rules the Heartland commands the world island. Who rules the world's island controls the world. You know, the heart of the world is located somewhere in Central Asia. Why do other conflicts and wars around the world not meet the same reaction as we can see today with Ukraine? So I'm not sure that this notion of heartland and geopolitical sort of mysticism is necessarily the response to why we pay more attention to Ukraine than to other wars conducted by Putin in Georgia, in Chechnya, and so on. For sure, the scale of the violence is a major one. The dimension of Ukraine is remarkable. The fact that Ukraine is a European state is also part of the response, perhaps, and the fact that this NATO is being framed quite explicitly by Putin as a sort of an element of the confrontation between Russia and the NATO. These are all elements that make this conflict particularly troublesome and relevant for any international observer. But on this, maybe Alberto can say also something about the the economic implications of this war, because it's a war that really, as we are noticing now, is affecting the whole, system of global economy, the chain of the value, the issue of sources of energy and so on and so forth.
Yeah. In fact, here we have to put in the equation of the war the economic relation we do have from a European perspective with Russia. We are too dependent on its energy, especially the gas. And if you look at the dependency of the gas, we have to open another box related to Libya, how Libya started to enter in a war situation, and following that war situation, we lost the connection with the gas reservoir we were used to import from Libya. As you know, the war in Libya started by US and France somehow, but the result is that we are out from that part of the world or in the conflict, and who is running the party is Russia. So Russia probably knew that we are in a very weak situation because of the dependency for the gas. And if you look at the sanction, I would like to open also this perspective, since economic sanction, after all, are somehow warfare. So sanctions are meant to hit a state. In this case, it is Russia. As guns are hitting people and buildings and infrastructure, but we have to look at economic sanction in a framework of the war. However, if we look at the sanction in the history, and especially we can frame the sanction against Russia following the Crimea annexion in 2014, we have to admit that sanction does not work. Does not work because they have even a boomerang effect. The economy in Russia, following the sanction enacted in 2014, boosted. If you look at the military expense, they started from 2014, probably preparing the second phase of the annexion of Crimea. The GDP grew at a lower market rate, of course, but still higher than Italy after all. The ratio of the public debt to GDP decreased constantly. That is to say, the Russia reacted to the sanction by making more resilient and strength the internal economy. If you look at the data I'm sharing to you, it is an evidence recorded by the Financial Times well before the beginning of the strategic army intervention in Ukraine, because it is dated 2 years back. And the results, this is basically a summary of what happened following the sanction enacted in 2014. And the result is that Russia and the government is even stronger than before. From the economic perspective, probably we have to admit we can do more, we can do differently. It's not only a matter of sanction, because after all, it doesn't work. I would also like to share with you in the chat another link that is very interesting, because it is written before the Russian invasion in Ukraine, so it is not biased by the latest news. It is that sanctions are are abused. There are too many. There are too many sanctions all around the world. If you use the same instrument for different situations, the result is that they are not effective. So even from this perspective, we have to admit that economic sanctions are warfare, are within the framework of a war. So they are somehow trying to hit the counterpart, but they are not effective. If we want to use economic sanction to reach somehow a different result, probably we have to admit that the only sanction is to shut down the import of gas from Russia, whatever it costs for us. We are just looking TV, but we are not suffering so much. If we wanted to hit the government in Russia, the source of their power and the source for their military spending, it is the import of oil and gas. But it is not on the table. We are somehow discussing if the import should be settled in dollars or in euro or in local currency, but we are not considering the hypothesis to quit and shut down the import of all gases, meaning that to finance the war, because every year we import roughly $500 billion of dollars in oil and gas. This is the source of their power.
Yeah, maybe you can also comment a little what Lorenzo asks about the oligarchs, so the individual sanctions, smart sanctions against Russian oligarchs. Is there any coordination between the states, including the EU, that are planning and implementing these sanctions? May these sanctions maybe make a difference?
To be honest, sanctions are fake news. Probably you heard about the shutdown of the SWIFT international banking settlement system. It is where the international banks are used to clear the transfer of money from banks hosted in different countries. None of the largest banks, namely the Gazprom Bank or the Cedar Bank based in Russia, are out of the SWIFT. Again, if we want to really hit Russia by using a special weapon, that is an economic weapon, we are not using them. SWIFT is still fully operating. Gazprom is still fully receiving cash because Gazprom, I'm mentioning the first cash cow for the government that is selling the gas. 40% of our gas is imported from Gazprom. Gazprom is based in a tax haven, based in the European Union, namely in the Netherlands. So all the cash is offshore. It is not in the Russia. It is already in Europe, in the Eurozone, in the Netherlands. All the oligarchs hold their capital mostly in Switzerland. Cyprus was the former tax haven, again based in Europe and Eurozone. So that is to say, we could have many more economic weapons to use, but still we are neither considering to use none of them. SWIFT is operating, tax haven are operating, offshore cash is still banked in tax haven within Europe. Switzerland is Europe, not the European Union, but still Europe, and Eurozone, namely Cyprus and the Netherlands. So we have to admit, probably we don't want to touch the inner part of the Russian oligarchs, like the question made by the students try to address. So we are still ineffective if we look from the economic perspective.
If I may, just quick comment on this, very interesting observation. So I'm typing on the chat a link from Lighthouse Reports, with which I'm working since a few years now. So there's a database collected by civil society on who are these oligarchs, because we know their names. They have been published on these public documents. But so this database that is being collectively built up every day, they provide some more indication what kind of economic activity these people conduct, where they are based, what kind of assets they have been targeted. Second comment is that I was quite surprised that among the sanctions, European Union also adopted the sanctions to blackmail or to close down Russian Today and Sputnik, which are two media that were present. That as an open source investigator, I used to use a lot, actually, especially Russia Today. They have a lot of video footage from different armed conflict, especially in Yemen, in Syria, raw data that must be verified for sure, but still, it was a relevant source of information. So I wonder what's the meaning behind these, what's the rationale behind this measure. I believe that newspapers, whatever they finance or control or directed may be, that they're not the threat to inform political opinion. They can be, in a way, debunked, or they can be criticized, but to close down a newspaper, it seems a bit harsh to me. So I also think it's a kind of a reciprocity measure. That means that since our journalists cannot operate in Russia anymore, we close down Russian newspaper in Europe as well, which again doesn't sound very in line with the UN multilateral spirit of international law. So that's kind of a provocation or open question to anyone who wants to pick up on this.
Yeah, sure. It's really going to be a global world where also culture, information, propaganda, and so on play an important role. And maybe these measures that you mentioned about the two TV chains proves that we in Europe feel a little sort of vulnerable to the Russian propaganda, which is true, is a realistic observation. We have to just look back some years or months ago, what was the status of Putin as a political leader, and still many people admire this this person, exactly because the things he does and the way his deeds are portrayed by some TV, journals, propaganda, and so on. So, but anyway, yes, I can agree that this is a sort of evidence of some weakness. I would like also to add, not to add, but just to highlight what Alberto was saying about the global dimension of the movements that have surrounded and prepared this attack on Ukraine. So it's not by chance that some African states did not vote in favor of, recognizing the aggression of Ukraine by Russia. There are many states in Ukraine which have been infiltrated, let's say, from various perspectives in the military dimension, with mercenarism, or in the financial field, etc. This is not something that was taking place in the last few weeks. I mean, this is a long run strategy that Russia has launched years ago, and that is now maybe achieving some concrete results, if you like. Look at Mali, look at the Central African Republic, so on, places where the Russians are imposing, in a sense, their hegemony. Not only in the military field, but also to a certain extent also in the political discourse and in the cultural dimension.
Lilia has a comment on Russia 2024. Russia 24. So she's just stressing that it is a state-owned channel, and the level of brainwashing this is kind of certain. I mean, I think that Lilia would know, better than me probably, but we do have evidences of the fact that it is very, the use of media in Russia is at this point borderline fully fledged authoritarian. I mean, we are like in the lines of the guidebooks of what authoritarian leaders do. I would also, again, I know that it was a provocation, and I do think that it's very wise to think about this. Happened with the war on terror. This happened during the Cold War. We have to remember who we are, right? As the law lords from the House of Lords that is now extinguished in the UK said when they took a decision about anti-terrorism laws passed in the UK. They said we have to fight this with our arm tied behind our back, because this is who we are. Should we use the same tools, the same strategies and techniques that are being used against us, we would not be who we are. So again, I do see the value of the reflection and of the provocative question. Having said this, I really like to bring back into the conversation the relevance of the political networking that has been cherished by a lot of politicians in the European Union member states. The role of financing specific media and the role of pro-Russian propaganda in the context of political communication in the context of the European Union. Having said that, I totally agree that there must be an open debate about the possibility in fully fledged democratic states to be able to vet the information that we are fed, and to be able to distinguish to assess ourselves what is reliable and what is not. However, the capacity of Russian media to convince Russian people is really astonishing. And I'm basing this statement solely on recollections from people that are maybe reaching out home. They live here, they reach out to home in Russia, and they are just not talking about the same facts. They're not talking about the same, and they're being pushed back by their own families, and it's a very powerful tool, the Russian communication. But I do see the point that Stefano was making. So,
yeah. So if we don't have more questions from the audience, I think we can.
May I just comment
Sure.
back, because I think thanks Sarah for picking up my provocation. I do have a very specific perspective on this as an open source investigator, right? And we should also recall that, for example, the Al-Gwerfali case at the ICC was based on a propaganda video that was broadcast on social network by himself, by his militia, right? So what I mean is that if we close down Russia today or Sputnik, it may be that we closing our eyes on things that might be evidence for their own accountability. No one here is claiming that Russia is not an authoritative state, right? But this kind of information may be relevant for other purpose, despite the fact that it might be kind of worrying the effect that have on population. I like to play the devil's advocate as a lawyer myself. BBC is owned by the British government as well. So the most impartial and objective media channel is actually owned by a state authority, right? But no one would say that BBC is not reliable because of the quality of the work that they do, right? Again, as an investigator, I like to verify things rather than say, no, you should stay in silence, right? And if Russia, for example, repressed violently LGBT community that comes from Western in Russia, we shouldn't do the same in Italy because they are Russian and they come from a regime that is repressive with minority, right? So what Sarah was saying, the war on terror is really worrying in a way. The measures that we have adopted in Guantanamo, and all the effects on international relations as well, and law is really worrying. So we should try to see some boundaries, right? But thanks so much for this event, and thanks for picking up this provocation.
Yeah, a comment from Gulboker says that as a person from Russia, I can say that propaganda level there is insane. She also says that in big cities like Moscow and St. Petersburg, people are trying to know the truth, but in other smaller cities, where the elderly population exceeds, for example, is very hard. And another comment, sorry, a little longer, I read it with you. Perhaps we should also begin to reformulate our international economic relationships. We have reached this point because our leaders have tried to hold on to Putin, but even before that, to many others. And I want to point out that within our own European institutions, there are still politicians who have supported Putin, not to mention that within NATO and the EU, there are elements that are anything but democratic. So this is the comment by Medea. Yeah, of course, Putin is, in a sense, the son of the time, a product of our times, and we have, let's say, tolerated and nurtured a lot of similar elements, including in Western states and so on, and politics, the policies that, or the politics that Putin is enacting now and implementing, in a sense, are not technically so, detached from any other politics of imperialism and power that also known suddenly, that also Western powers have, pursued in the recent past. Of course, this is coming to some extreme and in blatant violation of international law, but we have prepared, in a sense, the situation for the emerging of such, gross violations and radical breaches of the international standards. Well, this was, in a sense, the inspiration of this meeting. So start to look at this crisis not only from the the viewpoint that is mostly emphasized in the news, in the reports, in the newspapers, and so on, that points at the strategic dimensions, the political what the politicians, in a sense, are telling us about their supposed strategies or intentions. We tried to step back a little bit and look at what in the legal discourse these facts are meaning. And the challenge is that on the long run, the international community have to stand from the legal viewpoint. Are we entering a new system? Are we entering a new kind of bipolarism, a new era of bipolarism in which some achievements that we believed to have got concerning the idea of living in a single, community that encompasses more or less all countries and all states is come to an end. Okay, and should we start thinking of two different and opposing versions of international law? I hope that these reflections can continue and can maybe be carried out with the contribution of people really from all parts of the spectrum. I mean, involving also Russian thinkers and lawyers, the Chinese side, and so on. One risk that we probably should avoid is to really fall into the pitfall that Putin is preparing to us, that is dividing the camp into two parts. Those who stay with the autocratic states that are now leading the game, or those who remain in the camp of the democracies, and so on and so forth. And don't consider any dialogue with those who live in the other side. So I hope that this kind of conversations can actually continue also among the students, among ourselves. The last comment comes from Lorenzo. Aren't there ways in which states and international organizations can support the dissent that is present and growing in Russia? Or do you all think this is something that should be done mainly by the civil society? So can states, governments try to support civil society in Russia, if I well understand what Lorenzo was meaning? What do you think? Is it something that only parallel organizations of civil society should do with their limited means, or states also should be involved in these pro-democracy efforts that still exist and can take place in extreme situations in Russia?
Well, normally when this was done in the past, if you consider it now, it's not a good thing, right? So the Orange Revolution, the elections in Serbia, anything that has to do with the so-called electoral warfare that was initiated after the mid-1980s, after the famous declaration by Ronald Reagan, right? We're not going to shoot down anyone anymore. We're just going to support democratic dissent in states. Of course, he didn't lay it out like that, but technically that is what happened. And we've been doing this, and the reaction but again, if you think about it, if we were to analyze all of these cases now, you would probably all agree on the fact that it's not good. It's an intrusion, it's a violation of national sovereignty. This should not be done, and so on and so forth. So are there things that nations can do? Yes, there are, but I don't think we would like them if we were to see them in action, right? Because it's basically funding opposition movements. And it's just not. On the other level, if I may, on the civil society, I'd like to remind that I'd like to recall the fact that what was it, right before the Sochi Olympics? I apologize if I'm getting the timing wrong, but in Russia, all NGOs, it became mandatory for all NGOs active in Russia to register and to prove that they were not paid, influenced, financed, or linked to any foreign entity, which again, it's not something which is super specific of Russia. Israel has a very similar law, so I'm not implying that Putin has approved Putin, that Putin is, but the Parliament of Russia has passed a law that is absurdly peculiar. But again, there are pros and cons in thinking of supporting the opposition in a third state. Think of the way the approach of the European Court of Human Rights on the Navalny case played out ultimately. The reaction on the side of Russia has been one of absolute rejection. Probably it kind of triggered the threat of getting out of the court and thus stopping financing with his own quota, with the Russian quota, the court itself. So again, yeah, I think it's a very complicated issue. And if I may, the whole idea of liberal state because every time that we discuss the concept of democratic states and authoritarian states, if I may, there are two levels which seem to be relevant. One is that of the opposition, of the definition of what we consider democratic. Putin, Xi Jinping, they consider their own systems fully democratic in their own understanding. But Putin, Orban, they reject the idea of liberal democracy, which they tie to the Western culture. Having said that, if I may, and I conclude, there is something very basic about the play out of, if you will call it, the Putin's regime, right? The playbook of the growth and then the fall of an authoritarian regime is very basic, and it follows the same steps all over again. If you were to see Nazarbayev in Kazakhstan, if you were to see, we've defined it as smart authoritarianism, right? At a certain point, you need to survive. You need to keep the system going, and maybe certain actions and certain positions can be explained from that perspective.
Thank you. We haven't talked much about Ukraine. Ukraine is standing the attack, the invasion, and also probably will be standing the conflict between these two camps that are taking shape in the world. And I think that if I may put a sort of final word, because we are going to finish now our conversation, you know, apart from the international law discourse that we have, you know, tried to address today, our attention should also go to the situation, the humanitarian situation in Ukraine, but also more in general, the risk that Ukraine may become the battlefield, not only for armies, but also for ideology, for you know, different worldviews that may become violent, intolerant, and attract even more violence, not only between states, between powers, but also within the population. So we should also, with people who are now fleeing in Europe, in the EU states, and so on, try to really start with them some peace conversations, if I may. And international law is one point. I still believe that international law can be a tool for achieving peace, and but also many other examples can be taken, and many other routes can be explored. The important thing is to really not to make of Ukraine another kind of Afghanistan, another kind of Libya, another kind of Syria, so places that for generations will produce more and more violence for themselves, and also perhaps for the rest of the world. I hope that this won't happen, and I hope that this can be prevented also I mean, doing our job in the universities, in the civil society, so on and so forth. Sorry. Lilia is asking, what kind of possible violence are you referring to within Ukraine if the vastest majority of Ukraine supporters European integration? What would be the ideological divide? Well, just a continuation of this war for generations. Okay, even when the army would stop their fighting and an accommodation can be achieved at the political level between the leaders, still a division might remain between those who survived the war. If we don't really try to create the conditions for a real peace in Ukraine, and not just you know, the division of the country between the two sides, or you know, the taking of the power by one of the sides. Okay, and yeah, we have many examples of these. We have examples of a population that after generations still are incapable of you know, creating a condition for peaceful you know, coexistence. I'm not saying that this would be the fault of the Ukrainians, but this can be, you know, a consequence of the war that Russia started. Okay, I thank all the speakers of today, and also the participants, those who attended our conversations, this webinar. Of course, you can find the whole webinar registered or somehow recorded, I don't know, on YouTube in the page of the department. The department has a channel on YouTube where some, you know, initiatives like this are still available. Okay, so thanks to Stefano Trevizan, our main speaker today, and thanks to Sara, to Alberto, to Tarcisio, and again, see you around and keep going.
Thank you, Professor. Bye-bye.
Bye-bye.
Bye-bye.